Hello friends, in the series on the income tax cases, today we will discuss a very important case in which the order has been passed when the company has been amalgamated. The name of the case is Deputy Commissioner of Income Tax versus Barclays Global Services Center Private Limited. This case has been reported in 103 ITR Tribunal at page number 100. The matter has been decided by Pune ITAT bench and the date of the judgment is 2nd January 2023. In this case, A company was going to be amalgamated in B company. When the company was not amalgamated, or in other words, when the order for amalgamation was not passed by NCLT, the company which is going to be amalgamated filed its return of income. And the notice under section 143 subsection 2 was passed in the name of the company A who is going to be amalgamated. And when the notice was issued, up to that time also the company was not amalgamated. But during the assessment proceedings, the company got amalgamated and the NCLT order came about the amalgamation and the company was not in existence after the company was amalgamated. When the assessment proceedings were going on, the assessee duly informed the assessing officer that our company has been merged into company B, so the order cannot be passed in our name. But in spite of that, the learned assessing officer passed the assessment order in the name of the amalgamated company on that date on which the company was not in existence and made some disallowances under section 10AA. When this matter came to the CIT appeal gave some partial relief to the assessee, but not on this ground that the company has been amalgamated into company B, so the order cannot be passed, meaning thereby that the CIT appeal didn't entertain the technical ground. Because some relief was given by the CIT appeal on merits, so department was into the appeal. So the assessee also filed the cross objections. When this matter came to the ITAT said that as soon as the company is amalgamated and the order of amalgamation has been passed by the NCLT, at that time the company ceases to be a person, meaning thereby that the assessment can be made only in the name of a person which is in existence. So the ITAT gave relief to the assessee on this technical ground that the order has been passed in the name of a non-existent company, and the ITAT held that in such a case the order is null and void. The department was contesting on this part that when the notice was issued and when the return was filed, the company was in existence, but at the time of the passing of the assessment order, the company was not in existence. So it does not make a difference. It was the plea of the department. But the ITAT held that whatever the case may be, if any order has been passed in the name of a company which is not in existence on the date of passing of the order, then the order will be null and void. On one point also the department was also contesting. The department was saying that since the company has participated in the assessment proceedings even after the amalgamation, so the order cannot be said null and void. So on this point the ITAT held that there is no estoppel to law. If the order is null and void, then even if the assessee had participated in the assessment proceedings, then even then it will not turn a null and void amnesia order into a valid order. So friends, we have to see from this perception that the company should be in existence at the time of the passing of the order. If the company has been amalgamated before that, then the assessment order will be null and void. But the positive point in this case on the part of the company was that the company has duly informed the assessing officer about the amalgamation during the assessment proceedings. So as soon as the company is merged, we should inform the assessing officer that the company is not in existence. In that case, we can save ourselves from unnecessary litigation. At the end of this video, once again, I am repeating the name of the case. The name of the case is Deputy Commissioner of Income Tax versus Barclays Global Services Center Private Limited. And this case has been reported in 103 ITAT Tribunal at page number 100. And the date of the judgment is 2nd January 2023. Thank you, friends.